Good morning, everyone, and welcome to another CDH webinar. Thanks very much for joining us this morning. My name is Richard Marcus, and I'm the moderator for today's event. It's quite clear that the new Expropriation Act has been one of the most contentious pieces of legislation to emerge in our new constitutional era. This is reflected by the fact that we have a record number of people who've accepted invitations to this webinar. Thank you for joining us. But that certainly reflects the importance and interest and, in fact, the concern that this new legislation has generated. To help us guide us through some of the key issues, we have a group of panelists from our firm: Burton Meyer, Belinda Scriba, Kuda Chimedza, Bridget Witz-Huensen, and Sentabali Makara, all of whom represent a range of our departments and sectors and who have a wide range of expertise in fields which are relevant to this legislation. Today, we can only touch on some of the main issues. We may well have follow-up webinars on more specific aspects, and obviously as things unfold in the public sector. We anticipate the presentation will be up to an hour. For those who want to ask questions, and you can submit questions on the Teams message board, we will leave half an hour after the presentation ends to deal with those. So we've got a lot to get through. Let's kick off and let's start with Burton. Burton, expropriation has always existed. Why is the new act so different?
Yes, good morning, everyone. Thanks for joining us. My name is Burton Meyer. I'm one of our directors in our dispute resolution department. Expropriation of land, where are we? We are where we were. Sorry to be so profound, but the new act is yet to be gazetted in terms of a commencement date. So we are where we were, but we need a plan for the future. And so that's why we do a comparative to answer your question, Richard, is, what is new? What do we need to be looking at? What do we need to compare with the old act, the 1975 Act? And really, I can highlight two things. I think the expropriation for null compensation is a key inclusion, section 12, subsection 3 of the new act. And then obviously they've slid in a definition called public interest, which is aligned with the Constitution. So I think those are the two main inclusions, the difference between the two pieces of legislation. And I think it really is the compensation for null value that is a big concern for everyone, and I think a lot of the people that are on this call.
Indeed. Now, already there have been indications, in fact, one constitutional challenge has commenced. What are the possible challenges to the new act in terms of the Constitution?
Yeah, it will be interesting to see what the challenges are. It's already started. The Democratic Alliance on, I think it was Friday, the 7th of February, started with with their application. But it was really limited. It was limited to procedural and substantive invalidity or constitutionality, and they really attacked sections 19.2 and 19.3 of the Act, and then said procedurally, the provincial members at the NCOP didn't have the provincial mandate. So I think those are the initial challenges in regard to vagueness and contradictory provisions. But I think that the challenge is going to come in regard to null expropriation for null value. I think that's where the challenge is going to be focused. And the question is going to be, does the Constitution as currently worded, does that provide for null compensation? It doesn't refer to null compensation, but can we say, as it says in section 25, subsection 3, that the amount of compensation and the time and the manner of payment must be just and equitable? When it says there the amount of compensation, does that mean null amount? Does it mean R1? Because one can bypass the null compensation, just say, well, I'm buying your land for R1 and I'm compensating you, which is not what the legislation is intended at. So yeah, Richard, I think that's where the main challenge is going to come in.
Thanks, Burton. Now, the issue of public interest, public policy, that's a key gateway, as it were, to the implementation of this legislation. Can you perhaps take the people who attended through those issues and explain them a bit more?
Yes, yes, no, 100%. And I think that's fundamental, Richard. That there is a starting point with this legislation. It is the Expropriation Act. It was unfortunate that just before the mining indaba in Cape Town that the president signed the act. And really, you've got to look at two main pillars in this legislation. The one is compensation. And if you're going to deprive me of my land, which is a entrenched constitutional right, there has to be a reason for it, because I'm entitled to my property. It's a constitutional right, but the Constitution, in particular Section 25, entrenches the right to expropriation in certain circumstances. And so the starting question, before you get into process, before you get into litigation and disputes, is the expropriation, the decision by an organ of state to expropriate land, is that in the public interest, and is there a public purpose? If you don't pass that milestone, if you don't pass that yardstick, you don't go past begin. You don't go to the next inquiry. You don't go to compensation and the like. And so, one has to look at those two phrases, because the Constitution specifically says in Section 25(1) that no law may permit arbitrary deprivation of property. And it goes on then to say in 4A, that the public interest includes the nation's commitment to land reform and to reforms to bring about an equitable access to all South Africans' natural resources. So, those are the questions that one has to ask. And then one looks also at the definition of public purpose in the Act, and that says any purposes connected to the administration of any law by an organ of state, in terms of which property will be used by or for the benefit of the public. And so those are the two key phrases that one is going to be looking at when one deals with the enforcement of this legislation and the expropriation of property or land. And I think it's important to consider those two aspects because it's key to understand them. But most importantly, when one comes to the potentially controversial portion of this legislation, which is Section 12(3), that's where one really has to look at, whether null compensation, is it ever a risk? And I think let's pause and just have a look at that quickly, because I think it's a very important provision. And given our limited time, we want to go to the nub of the issue. And it says in sub 3 that it must be just and equitable for null compensation to be paid where land is expropriated in the public interest, having regard to all the relevant circumstances, including but not limited to. And there's not enough time to go into all the examples. I think Belinda will touch on it later. But it's important when one deals with null compensation to know that they're talking about land. They're not talking about property. And the Constitution in Section 25, and specifically 4B, says property is not limited to land. But when it comes to null compensation, we're talking, first of all, about land. And if you want to offer null compensation, it must be just and equitable. And expropriating the public interest. And unfortunately, the definition, as a good Afrikaans saying, is "Hoe wyd is die Here se genade," is as wide as the Lord's grace. And so, unfortunately, the courts have not been specific and haven't set out in any detail what is a public interest. How can we define public interest, save for how it's defined in the legislation? And so when it comes to null compensation, we will have to see how that is interpreted by the courts. But I think it is important to have a look at those categories. And if you look at each one of those four categories, A to D, you're dealing with situations where either the land is not being used or the land has been abandoned. So it's not land that is being gainfully being used, etc. It's land that's not being used or has been abandoned. And that's what's envisaged in terms of this portion, except for paragraph D, and I think Belinda may touch on that a bit later. But we still have these two concepts of public purpose and public interest. And if one has to try and put two categories together, public purpose is probably more like where your state is authorized to build roads. It has to provide electricity, and they need land for pile-ups, where informal settlements need land. Those kind of public purposes is what we're talking about there. But when we're dealing with public interest, we're really dealing with the public at large. And that is potentially where there's the redistribution of land. And I think that's where people are concerned that because public interest and public purpose is not defined in 12.3, we have a situation where the courts may look at that and say, well, we're dealing with the redistribution of land, we're dealing with land reform, and we need this land to distribute it, for the public. But remember, it's land, it's not mineral resources, it's not shares in companies, it's not any of those. It's limited to land, and we need to be very aware of that when we look at this piece of legislation. But that's, there's a lot more that I uncover. There's a lot of past legislation, past cases that we can look at, articles that have been written. But I think I would use up the full hour. So I'm going to hand back to you, Richard.
Thanks, Burton, for that introduction. So we see that compensation is also a core issue in this legislation. Belinda, turning to you, is compensation the default position?
Seem to have lost Belinda.
Perhaps while we're sorting Belinda out, we can move on to another topic and I can come back to her. Kudat, jumping on in your section, you're involved in financials and advice to banks and lenders. What are the implications on this legislation from a financing perspective, particularly risks to lenders and security?
You're on mute, Kuda.
Hi, Kuda.
Apologies. Thank you, Richard, and good morning to everyone. I think we're going to need to consider how we're structuring our finance deals. I think an important aspect for feasibility and bankability for financing of certain transactions is securing property rights. This includes transactions for the financing of acquisition of farms, other commercial and residential property, and project finance generally. For that reason, the structure of the transaction is centered on ensuring property rights remain secured. And this is reflected in the terms that we see in funding transactions. This includes the representations and warranties that we see, the undertakings, the events of default that are included, and more so in the security package for the funding. Ordinarily, Richard, I think if there's land somewhere to be mortgaged, that's usually considered a strong security package. But given the criteria for land that may be expropriated in terms of the new act, I think Burton referred to land that is not being used. I think we now need to actually start looking more carefully at considerations such as the location and the use of the land as we structure our finance deals. Going to be sufficient to just sort of identify a piece of property somewhere and gain comfort from that. The new act also contemplates expropriation for both movable and immovable property. I think Burton touched on that as well. Many of us have been considering the implications on immovable property because that's where we actually have potential for no compensation. But implications on movable property in financing transactions are definitely a space to be watched as we continue to learn more about the act. And I think just a final point from a financing perspective is that the new act, much like the old act, provides that expropriated property shall remain subject to all registered rights of third parties except mortgage bonds, unless such rights have been expropriated from the owner. I think it remains to be seen in that regard if this will extend to general notarial bonds and special notarial bonds, or if it'll be limited to mortgage bonds.
Thanks, Kuda. And what can financial institutions do to protect themselves if they need to protect themselves? Is the protection automatic in the act, or do they need to take steps to secure their position better?
I think there's definitely ways we can reduce vulnerability without necessarily needing to reinvent the wheel. I think many people are panicking because the base for many financing transactions is our bonds. But the existing standard loan market association provisions already protect the lender's interests in respect of secured property. In that regard, we typically see terms in financing transactions that include a strong security package with mortgage bonds in respect of immovable property, general notarial bonds bonds in respect of movable property and special notarial bonds in respect of specified movable property. We also typically see representations and warranties relating to ownership of property that the lender is concerned with, whether from a security perspective or if it's actually the basis of the transaction. For example, when we're acquiring land, we also typically see representations and warranties relating to ranking of the security that's been provided and the value of the property in question. Additionally, we see undertakings relating to valuation of the property and events of default that are linked to expropriation itself. So taking into account the circumstances under which land can be expropriated, what Britain's taken us through, lenders may want to consider just bolstering the existing standard terms. For example, lenders may consider introducing mandatory prepayment provisions. So the new act speaks to the fact that an agreement needs to be reached between the property owner and the mortgagee as to how compensation funds are to be distributed in the event of expropriation. So lenders may want to consider including a prepayment provision which effectively says, in relation to the proceeds of expropriation compensation, the funds will be paid over to the lender directly upon receipt. And it's important to know or to acknowledge that this is not reinventing the wheel. We already have similar provisions relating to proceeds from insurance claims, proceeds from disposal of material assets. So effectively, this would just be an additional prepayment provision, which ensures that on receipt of compensation proceeds, the funds are paid over to the lender. This is important to agree upfront in our transactions where property is central to the bankability of the transaction so that the parties avoid unnecessary agreements to agree at the time, because that is actually unenforceable in our law. It's also important because the Act provides that if the parties fail to reach agreement on the distribution of the funds or fail to provide such agreement to the expropriating authority within 30 days of the date of expropriation, the compensation funds will be paid over to the master of the High Court to be held in the Guardian's Fund. I think we can all agree that this is not a favorable position for any party to a funding transaction, whether lender or borrower. And finally, it's important to agree to this upfront because the Act provides that if the parties fail to reach agreement on the distribution, then the parties may apply to court to make a distribution. Now, I mean, we're all aware of the length of litigation proceedings and the costs involved. So again, preferable to just include that in your prepayment, mandatory prepayment provisions upfront. Then just to add on, I think lenders may want to just relook at their standard warranties, given that we have an indication of the criteria for expropriation of property. One might just want to include warranties to the effect that the property in question does not meet the criteria. So effectively confirming that the land is in use, it has not been abandoned. This would also, of course, apply to both movable and immovable property, just bolstering the warranties that you have in place. Similarly, lenders may also want to consider including undertakings that relate to notice of any change in circumstance that speaks to the qualification criteria for expropriation. Our existing material adverse change provisions, which are linked to events of default, already take into account events that may have an effect on property of the borrower or security providers. So it's just a matter of bolstering existing provisions that we have. We don't really need to scratch our brains and try and reinvent the wheel in this regard.
Thanks, Kuda. And Bridget, turning to you, you've worked in property for a long time. You deal with developers, you deal with holders of security. Can you perhaps, and of course, this is a cause of great concern in the Act, this is where the anxiety lies. Perhaps you can take us through some of those issues and explain how the new Act may impact upon those kinds of issues.
Thanks, Richard. I think a lot of those issues that you mentioned have been covered by both Burton and Kuda. And I think it is at the moment that because we don't know how this Act is going to be implemented and how it's going to be, or many of the provisions are going to be interpreted, that is where a lot of the fear that we're experiencing is actually coming from, which is understandable. Fear of the unknown is very real. When we know clearly how something is going to be implemented and the steps that are going to be followed and exactly how it's going to be interpreted, it makes it a lot easier, but we're not quite there yet. But I do think that it's important to reiterate, firstly, that nil compensation is definitely going to be the exception and not the rule. I don't think that that is something which is going to be at the forefront of all of this. Secondly, we have had an Expropriation Act in force for many, many years. So it's not something that is entirely new. There obviously have been certain fears about it in the past in terms of implementation, but the real fear now lies in these new provisions and how they're going to play out in reality. So I think we just need to take a step back in many instances and look at the factors that Burton has discussed, look at all the hurdles that we need to overcome, firstly, to get to a point where we are expropriating land. If we are in that realm, looking at the factors of public interest and public benefit. And then once we have passed those milestones, there are a whole host of other hurdles and factors that need to be considered before we actually really get into a finality or get into a point where we are expropriating land. If we look at the Act and the implementation of itself, aside from the public interest and public benefit, it actually speaks to the fact that one cannot implement the Act itself until there has been an attempt to agree with a landowner or other interested parties on acquisition of property for on reasonable terms. So before we even get to those expropriation situations, there is, in fact, in the Act itself, measure for pre-steps to have been taken to avoid the implementation of expropriation. So there's a whole host of things that are happening in the background before we reach this point. And I think it's important that we don't lose sight of that because it is very easy to look at the worst possible cases and the worst scenarios that play out. So for now, I think it's important, as Kuda has mentioned and Burton as well, to kind of look at the scenarios where we might be placing ourselves in an unnecessarily risky situation. So finding ourselves where we are potentially going to fall within the realm of the Act. So from an investment point of view, avoiding purchasing property in very outlying areas, perhaps, or in combination with that property in outlying areas which hasn't been used for extensive periods of time. So there are definitely some practical things that we can do to avoid placing unnecessary risk on these sorts of transactions and property investment. We certainly are not looking at the Act from a perspective of people's residential homes being expropriated, high dense areas, successful running farms. I don't think that is going to be where this Act finds implementation. I do think that we're going to have to look at land that's not being used, perhaps state land, at the forefront of all of this before we even consider anybody having their land expropriated where it is in fact being used. And then just being mindful, again, of those factors, location and use being primary ones, avoiding situations which might look like land has been abandoned. Please don't let your rates accounts be unpaid for several years. That's not going to look very good. So keeping those practical things in mind. And then many of the factors which Kuda mentions as well from a lender point of view, perhaps building in additional clauses or safeguards in respect of their security. We do already have in mortgage bonds clauses that deal with expropriation and how compensation needs to be paid in those instances where land is expropriated. So it's now just looking at bolstering certain of those provisions, making sure, as I say, that we mitigate the risk as far as possible while we're still in this process of fine-tuning the implementation of the Act.
Thanks, Bridget. So what you seem to be saying is there are a lot of protections and it is going to be an unusual circumstance in very particular factual scenario which leads to this risk of a nil compensation.
Absolutely.
Good. Thanks, Bridget. Now, hopefully, Belinda sorted out the technical problem and we've talked about compensation. Belinda, take us through that. I asked the question, is compensation the default position and what's the situation there?
Circumstances, and the government there has been an expropriation bill since 1975, and the government hasn't abused that bill as far as we've been able to ascertain. There might be one or two scenarios where people feel that it has been abused, but it hasn't been abused to date, and there's no reason for us to think that there's going to be any sort of abuse now. As Burton's alluded to, it has to be on just and equitable grounds. It has to be for public interest. And public interest in terms of the Constitution seems to have been defined to specifically deal with the rectifications of injustices in the past. So it will probably very much focus on redistribution of land in order for people to be relocated rather than infrastructure purposes for expropriation. And again, it is limited to land. I know that's cold comfort to people that it's not limited, that it falls under the entire auspice of property and that it is limited to land, but it is very much limited to land, and therefore it's very likely to exclude, for example, mining rights or leases over the land. So I think people must take a little bit of cold comfort in the fact that it has been limited and limited to quite an extent. The limitations also fall in terms of what they've listed as what can be viewed as possible expropriation for nil compensation. Sorry, I'm still on. Can you still hear me, Richard?
I can see you loud and clear. And hear you.
I'm so sorry.
Very loud.
What has been listed very specifically, and I'll go into the specifics a little later on, but what has been listed specifically is the focus will be on land that is not used, whether it's by organs of state or by individuals. So the first that's listed is land that is not being used and its main purpose is not being purchased for development, but specifically for the benefit of appreciation, so speculation. Then there's the organs of state don't escape this either. If they haven't used the land for their core functions, and it's unlikely that they're going to be using that land in future for their core functions, and they've acquired that land for no compensation, then they're also vulnerable to nil compensation under the Act. The other factor that they've listed is if the property appears to be abandoned. So there has been no control that's been affected over the property despite being capable of being affected. So this, for example, could be abandoned buildings that have been very much in the focus in the Joburg community in terms of hijacked buildings. So it could possibly won't be one of those scenarios. And then the last one is if the market value of the piece of property is equal to or less than the present investment value or subsidy that the government has put into the property and the beneficial capital improvement of that. So it is very limited in terms of its focus. What is concerning a lot of people is the fact that the clause is caveated by all relevant circumstances, including and not limited to. So the question is then, how wide can that be interpreted? I think the silver lining in this is that it's not just limited to these four factors necessarily. People will have an opportunity, even if they fall within these four factors, they will have an opportunity to present other circumstances in order to justify that some compensation should be given, even though they fall under these four caveats. So I hope that answers your question, Richard.
It does. Thank you, Belinda, and thanks for coping with the technical stuff. Challenges to valuation decisions. Centre Varley will talk to process a bit more, but can you isolate the challenge to the valuation from the expropriation quantum from the expropriation itself?
Yes, it can be isolated, Richard, and you can see that in terms of there's very strict provisions on how you calculate the compensation. As Bridget alluded to earlier, there also has to be very much of a consultation process, not just in the calculation of the amount, but also in how the process, whether or not the land is actually suitable for expropriation in the first place. So there's a lot of investigation that goes into whether the land is suitable for the purpose for which it's going to be expropriated. And then once the decision has been made, then there's also a consultation process on how that needs to be affected in terms of process. So it is very much there are a lot of factors that need to be considered, and one of them obviously for very obvious reasons is compensation, and Section 12 deals with the compensation in normal circumstances. So Section 12 lists things that must be taken into account when the authorities are thinking about amounts, and things that shouldn't be taken into account unless It's just and equitable in very special circumstances. What those circumstances will be have yet to be defined, and whether or not those are taken into consideration. So what should be taken into consideration, as listed in the Act, is the current use of the property. So what is the property currently being used for? As one of our viewers has alluded to in their comments on the side, that you do have to look at the historical acquisition and the use of the property. So how did the owner come into owning the property and the process in which that was taken historically? And then the current market value of the land is a factor. And then the extent of direct state investment that's already been placed in that land and the beneficial capital improvement in that land needs to be taken into consideration. And then the last piece is the purpose of the expropriation. So it has to be a specific purpose, and a purpose obviously for public interest. It's very defined as public interest. So it's talking about public interest versus the interest of affected parties, not just the owner, but all affected parties. So, for example, if you've got solar panel cell towers on that piece of property, if you've got servitudes over that property, if you're leasing it for residential purposes, for example, everybody's interest needs to be taken into consideration. What shouldn't be taken into consideration, as I said before, unless there's special circumstances that justify it on just and equitable grounds, are the following factors that have been listed. So the fact that the expropriation is happening despite the dissent of the owner or any property right holder. So even if there's not consent, that doesn't need to be that mustn't be taken into consideration when deciding on the amount. Then the special suitability and usefulness for which the expropriation is happening, unless that is something that would be viable in the open market. So an example of this is if it is a piece of farmland that seems to be suitable for a dam in order to avoid the drought situation that Cape Town had a few years ago, then that's not something that would be sellable in the open market. So therefore that can't be taken. So the fact that it's going to be a dam can't be taken in as a factor. And then the enhancement that equates to unlawful use of the property. So just a very arbitrary example is if you've built a building on the property in order to process not marijuana, that's legal now, but to process heroin, then of course that enhancement and the value placed on that building can't be taken into account. Then any improvements to the expropriation notice has been delivered. So if you're trying to improve the property in order to get a better price, this shouldn't be taken into consideration unless it has been agreed with the appropriation authorities, or unless you're obliged under some other circumstances. If there's, for example, if you need to have a specific building on the property because of its current use and you need to have that building on the property, or if there's a contract that obliges you to put something on that property. Then the other one is anything done with a specific purpose of obtaining compensation for that property. And the last factor that's considered that shouldn't be taken into consideration is any enhancement or depreciation directly attributed to the purpose for which the property is being expropriated. So they have listed very specific factors, and whether these factors are going to be broadened or not, either in regulations or in court interpretation, is yet to be seen, Richard. And I hope that answers your question.
Thanks, Belinda. That was a very comprehensive explanation. Now, we can see if we look at the Act that there are a lot of steps that have to be taken. It's very process-driven, and I'm very pleased to introduce Senator Bali, who is an expert in this area. So, Senator Bali, if you could take us through how this whole Act will work as a process of expropriation, what has to happen, and the protections that exist there.
Thank you very much, Richard, and welcome to everyone for joining us this morning. So let me maybe start about the process in terms of the Act. So the Act provides for expropriation of property for the public interest, unlike the old Act that was always focused on public purpose, which there's a big distinction between the two. Now, public interest, for example, well, let me maybe start with public purpose. Public purpose means that it relates to government projects, like, for example, building of roads, any of the current servitudes that you would see on roads, bulk infrastructure from Eskom, telephone lines from Telkom. That's usually what we deem as public purpose. And for example, maybe in the new age, we would also deem public purpose being the installation of fiber lines in various properties. Now, the Act defines public interest as including the nation's commitment to land reform and to reforms to bring about equitable access to all South Africa's natural resources in order to redress the results of past racial discriminatory laws or practices. Now, the above makes it clear that the Act is enacted to give effect to Section 25 rights of the Constitution and should not lead to be read in isolation with any of the other equality provisions and other judgments that have come dealing with Section 25 rights and how they are exercised. So there's not a complete disregard of what has been applied in terms of the old Act. Now, prior to turning to expropriation process itself and nil compensation as has been dealt with by the other speakers, it is important that, again, we highlight that nothing precludes just an equitable compensation or expropriation without compensation in terms of Section 25 of the Constitution, provided that equitable balance between public interest and the interests of those affected having been considered. Now, what are those factors for just and equitable compensation? Well, first and foremost, the current use of the property is very relevant. The history of the acquisition, which means what has been the chain of custody and control over that respective property over a period. The improvements made on the property, which obviously speaks to value. If there was any state investment made on the property and the purpose of the expropriation. I'm going to go back to the two last points, which is if there's any state investment made on the property and the purpose of the expropriation, because I think it's very important when you start looking at actually what is the process itself for expropriation. Now, it's also important to note that whilst it may be possible to arrive at nil compensation, it would be extremely rare circumstances that would enable nil compensation as the Act and how we are starting to speculate, because this Act is not being in effect. But looking at how the old Act has been applied, the circumstances for nil compensation, I must say, it's a very narrow and very difficult test to come to. Now, the expropriation process in terms of the Act. Now, Section 7 speaks to this. First, it starts with a notice to expropriate, which must be served on the owner, mortgagee, or holder of the right. Basically, any person that actually has a right or title to that specific property. And with such notice requiring the publishing of that specific notice in terms of Section 22, which in the Act actually prescribes to you what the process would be and how actually effective publishing and notification of the public at large, but also any affected persons would be. Now, it also further to this Section 7 says there's certain things that must be included in that specific expropriation notice. And you'll see actually with the understanding of what is being required for you to include that in so doing, once you start complying, that you can then start seeing the checks and balances mechanism going. The right hand must always know what the left hand is doing. So one of the things you need to include, the statement of intention to expropriate must have a full description of the property, a short description for the purpose for which the property is required. That's very important. The address, of course, is very important. But another thing that's also very important for me, the reason for intended expropriation of a particular property needs to be outlined. The date, if any, that's been determined, or obviously this can move, as we've seen in other previous expropriations we've been involved in, that the date shifts. But something that's also very important, it puts an obligation that an invitation must be published of the intended expropriation, which must first be lodged with an expropriation authority. And within 30 days thereafter, publication must be made to all affected parties so that objections can be presented to each and every speaker. Notably, an expropriation notice must also include an offer of compensation, which the expropriating authority considers just and equitable, and an explanation of how the amount was arrived at with reference to supporting information. Now, what that means practically is that before you can even start talking about let's work on a willing buyer, willing seller, you need to be able to put in your application and on your notice as to why you believe a certain value, whether you're using the willing buyer, willing seller, or using another valuation methodology for that specific property. So even, and as you've seen in the media, a lot of people have been speculating as to whether the determination would be whether you're a foreigner, whether you're a South African citizen, whether you are what is categorized as previously disadvantaged community or whatnot. Those questions start coming into the fore, and we're looking forward and excited to see what case law is going to come out of this. Because one scenario I've thought about on this is that as someone that deals a lot with community engagement and resettlement in the mining sector as well, and in farming communities where you're trying to move communities, sometimes for health reasons, for security reasons, but more importantly also for commercial reasons. Communities. So yes, there was a question that was asked earlier. This is one of the reasons why that compensation issues start becoming in, and the due consideration starts kicking in as well. Now, the other thing is that one of the things that the Expropriation Authority is then tasked with is then looking at what the representation was the motivation for the actual expropriation application, and what is the resistance for it. So that's where the balancing act then starts coming in, because in so doing there would be a consideration of it, and then a response and a decision must be made by the expropriation authority. Now the decision can be in twofold. It could be a decision that says that expropriation authority decides to expropriate, which means that there must be a notice now published in terms of the act on a reasonable time. Alternatively, your application for expropriation is unsuccessful, which again also requires publication. The other one saying that if there is expropriation, it must be gazetted, everyone must be notified. One of the other important things that the act also says is that it appreciates that some of these issues might come into litigation for expropriation, whether it's the litigation on the issue of expropriation and compensation, or the issue of, I don't mind you can't go expropriating, but I want fair compensation. Now, what the Act does specifically say in Section 19 says that one thing that can't happen is that the expropriation side of things in regards to any dispute that might arise will not be prevented by a dispute relating to the compensation part of it. So those are considered very separate in terms of the Act. Now, what is clear from the above process is that it's not arbitrary. There are checks and balances, and these checks and balances also speak to Section 33 and 34 of the Constitution, which speak to access to courts, but more importantly, just admin action as well. So I do think there is sort of a movement. I don't think there's too much of a departure from the old Act, other than certain refinements on the process and a bit of clarity, and also at the same time a bit of red tape being created by the Act as well. But I think the red tape creates so much layers that it actually prevents a situation of abuse of process, in my view. Now, while there is understandably controversy with regards to the Act, its purpose and process of expropriation clearly evidences the property as not being susceptible to arbitrary seizing. The process has its checks and balances throughout, and I do believe, again, that in the circumstances that we've had historically of no compensation, understand that it's not been a situation where there's just been a land grab akin to Zimbabwe, as I've seen in some media publications, but it's actually been a situation where there's been due consideration and no remember whether it's 100 Rand or 200 Rand, then no compensation is no longer in the fall. But definitely from my side, my view is that there's nothing to fear. We just look forward to the fine-tuning of it, either through regulation or ministerial proclamations on it, to see actually how many of these issues that are being also now tested in courts are going to be manifesting. Thank you, Richard.
Thanks, Nthabali. And just on that, you mentioned the challenges that can be mounted. At what stages of the process is there check and a balance? I make a decision, it can be reviewed, it can be taken to court. Just perhaps briefly tell our audience what can be done by a landowner who's, say, unhappy with either compensation or the expropriation itself.
So the one thing that's good about the Act is that it does have a built-in dispute resolution process. Now, before we even go to the Act, I would anticipate, and I would, in my interpretation of how admin actions are manifest, that in any event, any expropriation authority decision would be reviewable itself. So a review application in the truest sense would be possible. But the good thing that the Act has done in recognizing that, it's created a layer now in Section 19 of also realizing that the parties might want to mediate. So there's mediation available in terms of the Act. But more importantly, thereafter, there is a court process envisaged akin to a review process of the decision of the expropriation authority, whether it's on the issue of expropriation or the issue of compensation, and maybe some of the joint things. But there's an appreciation that not one size will fit all in regards to these applications. Circumstances will differ. Even the considerations of when to compensate and when not to compensate will actually differ. That's why I think there's a big emphasis on on this Act actually emphasizing continued discussion between the actors in a specific expropriation process.
Thanks, Senator Barley. I think a lot of questions have come through, and some of them feed back into some of the issues we've discussed. I'm going to go through some of the questions. I apologize to you if I don't get to everybody. We can also deal with these questions in responses after this webinar is over. But there's some very interesting questions, and I'm going to open it up to the panelists, but perhaps direct the questions at individuals initially who've spoken on the topic. So we have a question here from Charlene. Would the courts not interpret public interest narrowly, seeing as fundamental rights will be affected? And maybe, Burton, swinging back to you because you started there. What's your comment on that? Would the courts interpret narrowly?
Yeah, thank you for that great question. And I think, look, although there is a limitation of rights as provided for in Section 36 of the Constitution, there are questions that need to be asked in regard to Section 36. The purpose of the limitation, the nature and the extent of the limitation, the relation between the limitation and a purpose, and the purpose for expropriation is to provide much needed land for public purpose and public interest. So I don't believe that Section 25(8) limits a challenge on the basis of, for example, null compensation. In what instances should someone be deprived of land without being compensated for that? So, yeah, my answer to that would be that, subsection 8, although it refers to the limitation provided for in statute, and that's why we have the Expropriation Act, I still think that there are constitutional challenges and potentially valid constitutional challenges.
Thank you. Now, here's a very interesting one because it's I think, quite pertinent. And Sipe, thanks very much. She makes the remark, so in a nutshell, you are saying the past bill has a potential to expropriate even from the marginalized. In other words, the people from whose land was taken in the beginning. And Senator Barley, you answered that to some extent on in the chat, but maybe you can expand and give us a response there. That's a very interesting question. Senator Barley, are you with us?
Sorry, Richard, can you repeat the question? I'm having some issue here.
We can see you again. So the question's a very interesting one, and you started to answer it if you haven't answered. In a nutshell, you are saying the past bill has a potential to expropriate even from the marginalized. So even those people from whom land was taken in the beginning, and that's a very interesting insight.
So let's think about it this way, Richard. If you're looking at a mining right and the mining area in which that mining right covers, many of the times it does cover communities. Now, reading the Act as in its current form, without actually further flowers being put in it in terms of regulations and interpretation or proclamations, there is a recognized challenge with getting communities buy-in with regards to, for example, economic interest on a specific property. Now, I do not see a bar on a commercial individual company approaching an expropriation authority with the criteria put out in how the expropriation notice and application would be, motivating as to why, for example, a specific community needs to be moved. We've seen, for example, sometimes communities need to be moved from mining areas because of safety issues because they are too close to the mine. Now, we've seen also what challenges that presents in regards to how those communities sometimes provide resistance in actually being moved to alternative areas, and also in many other times this gets protracted over years, which defeats the purpose of why people. So I can see why the Act, for example, would not only go for the farms, the lucrative commercial farms, or would be going for any of the existing commercial properties, but actually going into communities. One interesting discussion I had last week in the Indaba was discussing about how many of these housing projects have been built on floodplains, for example, in Cape Town, which is a big safety issue that keeps, and we obviously, for example, in Western Cape, every year in those floodplains, there are floods in those communities, in those camps. Now, due to the affluction of time, those people have acquired certain rights in being in that land. But I do see an act like this one being functional enough to be able to be used amongst other legislations that already exist to be able to deal with such situations. So yes, definitely an act that doesn't only look at just an issue from a commercial perspective, but there is issues with regards to the end user. The end user could be a commercial interest, and to redress some of the past injustices as well. Thank you.
Thanks, everybody. And another question that came up, and I think Belinda might be best placed to answer this. Will this land include land that has already been expropriated in the past 10 years, but not utilized? So you can expropriate, then it remains unutilized. What happens there? That's also an interesting concept.
Thanks, Richard. If everyone will excuse me, I'm not putting my camera on because that's what caused the gremlins in the first place. So please apologize once again. So Richard, as I said in previously, is state-owned organs are not exempt from this act, and that's very clear because it comes out specifically in the nil compensation clause. So yes, I think if there has been expropriation, the land hasn't been used for the core purpose for which it was expropriated, the state-owned entities are exposed. So, and I don't think it matters when it was purchased. It will be one of the factors, I think, that will be taken into consideration as to when it was acquired under the general clauses of clause 12. But in terms of nil compensation, and it hasn't been used, then it may very well be open to that clause also.
Yes. So it's kind of a use it or lose it approach that, you can't
Absolutely.
sit on land and do nothing with it and expect not to be at risk of potential expropriation.
Just to maybe add there, Richard, sorry to jump in. There was a question earlier just in terms of where you acquire land with the intention to develop it, but you then don't develop it. How long is a piece of string? How much time, must pass in terms of my intention or my purpose to develop before it falls foul of the Expropriation Act. And so I think that's going to become a key consideration. And that comes into what's just and equitable. There was another question in terms of just and fair. But I think where you acquire land with a specific purpose to develop that land, then you don't fall into the null compensation category because there is intention to develop. And that takes time. You've got to do studies, etc., etc. But there's always the risk that in 10 years' time, if it's still undeveloped, you then may have a difficulty. But the mere fact that you acquire land to develop it and it doesn't happen within 2 days or 2 weeks or 2 months or 2 years doesn't mean now that it's susceptible to expropriation. Sorry, Belinda, to jump in.
No problem at all, Burton. I completely agree with you. I think that you must also be wary of trying to make it seem like the purpose is development when it's actually speculation and you don't do anything. I think that may come into the realm and may come to the fore. So I think that it is very much a use it or lose it. So I think if you do have intentions to develop and you haven't developed it in 10 years, but you've got perfectly legitimate reasons for not having done that, I think those reasons will be taken into account. But I don't think it must the purpose of development will be in the long term a reasonable excuse for somebody who's actually only acquiring the land for speculative purposes.
Thanks, Belinda. And another question which perhaps I should have put to Senator Bali earlier is somebody has asked, it's a very valid question, the legal costs associated with objections and or facilitating a settlement is a potential obstacle. Obviously, there may be landowners or communities on land who don't have the financial means to take on the state. Is there any way that is catered for under the Act or could be catered for?
Well, it's a very tricky one because obviously with, let's say the hypothetical of it is that any of these applications would be through a legal process with legal assistance being provided. Obviously that comes in at a cost. But where you look at the reading of the Act itself, other than the various steps, like, for example, the reasons for the expropriation and the calculations that obviously the calculation for compensation and how much due compensation would be, they would probably require some form of expert, being it a valuer in this regard, or, for example, a legal professional helping you to prepare that specific application. So there would obviously be a cost involved. But looking at the formulation of the Act and its recommendation on alternative dispute resolution mechanisms such as negotiation and mediation in terms of Section 19 prior to even going to a court process, you do see there's a genuine attempt to try and actually get this process across the line without having to incur much costs in protracted litigation on specific issues. Where I do anticipate it could get expensive is sitting at an example of a commercial property in which The issue is about the compensation versus no compensation, or the issue of how much actually it would cost. Although, for example, one can argue again to say that the Expropriation Authority has a decision that they take. Now, following that decision, it's still a question to me as to whether or not is it then a challenge on the decision of the Expropriation Authority, because it has the power in terms of the Act, not only to authorize the expropriation, but also to then agree on what the compensation would be. So I can only anticipate any subsequent mediation or court process would be on the basis of the decision of the Expropriation Authority. Therefore, seeing that that could possibly be a review application, which might invite lawyers, and I don't think they come cheap except for obviously us at CDH. You know, I do think that definitely there are costs involved in it, but I do think if the processes are followed properly, there is a rational way in which you can mitigate some of the costs. And at some point in time, the reality of the thing is that this is a human legislation, and humans need to first start talking before actually lawyering up on some of these issues. Thank you.
Thanks, Ntobali. And another interesting question, and this has received, I think, quite a bit of media attention. It's quite a political issue, is the image of South Africa and this fear that this act, if implemented, will discourage foreign investment, foreign landowners, foreign people who want to come and perhaps build a factory or do something here with land. Is that going to be a factor in how it's applied, practically speaking? Maybe Kuda, you can think about that, or Bridget is a property expert.
Thanks, Richard. I mean, I don't think there's a lot of reason to worry at the moment. Like we've discussed earlier, a lot of the protections that are in place still remain. But I mean, it still is yet to be seen how the act will actually be implemented, how the courts will interpret it. But at the moment, based on the information that we have, there isn't a reason to worry. I don't think it will have a negative effect on foreign investment and local investment.
Yes, and Bridget, from your side, I mean, you work in the property space. Have you received, at a practical level, have you received any feedback? Are you getting inquiries around this issue? What's the state of play, as it were?
We have had some inquiries, and I do suspect, as I mentioned earlier, that at this point it's because we're not clear on exactly what this process is or how it's going to play out. So I agree with Kuda. I don't think that, generally speaking, it's going to have an impact on foreign investment. At the moment, I think people are watching quite carefully to see how this plays out. There's obviously a lot of political background to all of this. There's a lot of views, a lot of opinions, a lot of interested parties that are raising their hand and raising questions. We have had one or two clients say, we're not going to purchase property for recreational purposes, for example. So people are definitely looking at the act and saying, okay, well, we've got properties that we've invested, there's factories on them, they're running, they're being used. Okay, that doesn't fall within the ambit of the act. But we're now cognizant of the fact that if we're purchasing land, again, for speculative purposes or something which might not be implemented in the sort of medium term, in the next 5 to 10 years, that maybe there is a risk there. So a lot of these things we have discussed, it's really is looking practically at where you're going to find yourself at risk. So from an investment point of view, if you've identified a property, whether you're a foreigner or a local investor, the land is currently being used, it's not been abandoned, you have intentions to develop or to build a factory or create a business, you're not likely to be falling foul of the act. So I think it is, again, comes back to these factors. We're not talking about property on the outskirts of Cape Town, which is ripe for investment and development and industry. We're looking at properties which are not being used, which are, well, first of all, potentially state properties. So there's a lot of options available for expropriation before we come into the realm of investment properties, and I think that's important to keep in mind.
Thank you, Bridget. And of course,
sorry, Richard, to interrupt again. I think just to add on to that, because I think investment in South Africa should be encouraged and not discouraged. And I think there are other pieces of legislation that will weigh in on this. There's the Protection of Investment Act that is there and deemed important enough to be in legislation to protect investors. And then obviously there's the bilateral investment treaties, where those either are still in place or where they haven't been or they've been repudiated, but they still have effect, there is protection there as well. So, I think one has to consider that. I don't think it's a matter of just investors should say, well, because of the act, I'm now going to pull out or not invest at all. I think there is sufficient protection for them as well.
Senator Bali, you want to add something to that as well?
Yeah, just maybe to add as well, Richard, again, I think I harp on the fact that there's been a lot of media sensation on what supposedly the act can be used for. But practically, maybe let's take the example of this legislation has been there before in terms of the old act. And what has the old act been used for? Now, the old act before dealt with the issue of public interest. And as being the usage, as I've explained before, they had to deal with a lot of infrastructure for the government, like, for example, the building of roads and everything else. But with the dawn of the Constitution in Section 25, all of a sudden, that morphed into what the Act now is confirmed. And what this legislation is now confirmed. Now, what has the old Act been used for when it comes to expropriation? What kind of properties has been used? And in actual fact, if you look at the example of some of the game lodges in the Greater Sabi Belt that have been, to a certain degree, expropriated, there were a lot of commercial considerations taken by government there. In fact, if you remember, there would have been a lot of criticism and media articles of how much actually compensation government had paid for those properties at some point in time. So the issue of nil now being a source of fear in this circumstance, and as Burton correctly points out, we have so many other legislations that prevent abuse of this one legislation to create the Balancing Act. And also we take comfort in the fact that, and I dare say that our courts are not captured, and our courts still have demonstrated time and time again to be impartial and be able to look at the law and do the Balancing Act required by the Constitution and its supporting legislation.
Yes, thanks, Senator Bali. And we're picking up questions as well on things like expropriation of viable farms. Somebody dealt with that, but of course, I think in the grand scheme of things, public interest would dictate that food security, for example, is very important in South Africa, and that would have to be a very large and practical consideration if a productive farm was sought for expropriation. Everybody, I see we've reached 10 o'clock. We still got some unanswered questions. We'll look at all of those and we'll respond to you. You're welcome, everybody, to address further questions or approach any of us to answer them. Thank you so much for taking time out of your day to join us, and please watch this space. We may well have follow-up webinars and Q&As on this issue as events unfold. Senator